Congress exclusive authority to secure fair representation by the states in the popular House, and left to that House determination whether states have fulfilled their responsibility. If Congress failed in exercising its powers, whereby standards of fairness are offended, the remedy ultimately lies with the people. Whether Congress faithfully discharges its duty or not, the subject has been committed to the exclusive control of Congress, an aspect of government from which the judiciary, in view of what is involved, has been excluded by the clear intention of the Constitution, cannot be entered by the federal courts because Congress may have been in default in exacting from states obedience to its mandate. The one stark fact that emerges from a study of the history of congressional apportionment is its embroilment in politics, in the sense of party contests and party interests. The Constitution enjoins upon Congress the duty of apportioning representatives among the several states according to their respective numbers, yet Congress has at times been heedless of this command and not apportioned according to the requirements of the census. It never occurred to anyone that this court could issue mandamus to compel Congress to perform its mandatory duty to apportion. What might not be done directly by mandamus could not be attained indirectly by injunction. Until 1842, there was the greatest diversity among the states in the manner of choosing representatives because Congress had made no requirement for districting. Congress then provided for the election of representatives by districts. Strangely enough, the power to do so was seriously questioned. It was still doubted by a committee of Congress as late as 1901. In 1850, Congress dropped the requirement. The Reapportionment Act of 1862 required that the districts be of contiguous territory. In 1872, Congress added the requirement of substantial equality of inhabitants. This was reinforced in 1911. But the 1929 Act, as we have seen, dropped these requirements. Throughout our history, whatever may have been the controlling Apportionment Act, the most glaring disparities have prevailed as to the contours and the population of districts. To sustain this action would cut very deep into the very being of Congress. Courts ought not to enter this political thicket. The remedy for unfairness in districting is to secure state legislatures that will apportion properly, or to invoke the ample powers of Congress. The Constitution has many commands that are not enforceable by courts because they clearly fall outside the conditions and purposes that circumscribe judicial action. Thus, on demand of the executive authority of a state, it is the duty of a sister state to deliver up a fugitive from justice. But the fulfillment of this duty cannot be judicially enforced. The duty to see to it that the laws are faithfully executed cannot be brought under legal compulsion. Violation of the great guarantee of a republican form of government in states cannot be challenged in the courts. The Constitution has left the performance of many duties in our governmental scheme to depend on the fidelity of the executive and legislative action, and ultimately on the vigilance of the people in exercising their political rights. Dismissal of the complaint is affirmed. End of Colegrove v. Green, an opinion of the United States Supreme Court.